What I want to know is what have you done since you've been on probation? So the violation of condition number 5 tells me that you haven't been reporting. And my understanding is that you were supposed to be at Pay It Forward. And
We are about to watch a probation hearing where the stakes escalate quickly. Carissa Johnson is back before the court after being placed on deferred adjudication for a criminal mischief offense involving alleged damage in the $2,500 to $30,000 range. The original supervision period was 3 years, but the court is now dealing with an alleged violation of condition number 5, failing to report to her supervision officer during August and September of 2024. And here is the critical part. Johnson pleads true to that violation. That means the court does not have to conduct a full evidentiary fight over whether the reporting violation happened. The judge explains that the plea could allow the court to find the violation true, adjudicate her guilty, and sentence her to up to 2 years in a state jail facility, along with a possible fine of up to $10,000. But this hearing is not simply about one missed reporting requirement. The defense is going to argue that Johnson has made efforts, spent substantial time in custody, participated in treatment, and has no prior arrest history. The state, however, is prepared to walk the judge through a much longer history of failed treatment, missed opportunities, and previous court interventions. Then comes the human side of the case. Johnson tells the court that she has struggled with her mental health, stabilized her medications, and believes she has finally learned from what happened. The judge listens, but then asks a brutally simple question. What have you actually accomplished while on probation? That question is going to become the center of this hearing. Will the court see someone who has genuinely struggled but is finally making progress? Or someone who has repeatedly been given opportunities and failed to follow through? Stay with this one, because the final sentence is not what either side requested.
Calling 2020 CR 11653, State versus Carissa Johnson. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense.
Jim Wheat for the defense.
And are you Ms. Johnson?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Carissa Denora Johnson who was placed on deferred adjudication in 2020 CR 11653 for the offense of criminal mischief $2,500 to $30,000 on April 9, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, review to the state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 5. In Bexar County, Texas, the defendant, Carissa Johnson, then and there failed to report to the supervision officer as directed for the months of August and September 2024 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State will waive all and abandon all of the conditions. Your Honor.
Any objections?
No objections.
You understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There's no agreement, Judge.
State, what are you requesting?
You're requesting 2 years in state jail with credit for the time the defendant was served in custody.
Defense, what are you requesting?
Judge, we'd ask for you to take a look back at her file and at the reports from probation. She has tried and has not done all that well in treatment, but during that time, she has been locked up a good bit while working with the court. She also has 240 days. Well, I was told 240, it might be 190, somewhere in that range of the amount of time that she has. Given her history, given the fact that she has worked with the court at different times and looked to work with the court, we're asking only that you give her credit for her time served, which I believe is 190 days. And I know she would like to speak to that too.
Now the defense is trying to change the lens through which the judge views this violation. Instead of focusing exclusively on the failure to report, Counsel is asking the court to consider the bigger picture. Johnson has spent a significant amount of time in custody, has participated in treatment to some degree, and, importantly, the defense emphasizes that she has no prior arrest history before this case. But notice the strategic problem. The defense is not denying that Johnson struggled with supervision. In fact, counsel openly acknowledges that she has not done all that well in treatment. The argument is essentially that the court should recognize the progress that did happen and give credit for the time already served, rather than impose another substantial sentence. That puts the judge in a difficult position. The court has to balance accountability against rehabilitation. Johnson is not being portrayed as someone with a spotless record on supervision, but the defense wants the judge to see someone who may still be capable of turning things around. And now Johnson gets the chance to tell the judge herself what has changed. Her explanation is emotional, but the judge is about to test that explanation against the actual probation record.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Carissa Johnson.
All right, what would you like to say?
Just that, with all this that I've been through, like mental health wise, I got back stable on my medications. I have learned my lesson. I have been in and out of trouble, but this time I actually stayed with the Center for Healthcare Services. I'm doing better, but I just hope that I can, I don't know what I'm trying to say. I'm nervous.
Oh, that's okay. There's no need to be nervous. I'm just here to listen and hopefully make a just decision in what's right. What I can tell you is, what I want to know is, what have you done since you've been on probation? So the violation of condition number 5 tells me that you haven't been reporting. And my understanding is that you were supposed to be at Pay It Forward. And I'm just saying that because your counsel asked me to look over your history. So were you at Pay It Forward? And if you were not, why not? That's a good program.
That answer from the judge is a major signal. The court is acknowledging that Johnson has done some things, but the judge is clearly not convinced that those efforts are enough to simply close the case with a judgment satisfied. And the next part of the hearing explains why. The state begins laying out a timeline of previous interventions, a surrender issue, an intensive outpatient treatment opportunity that was not completed as expected, a later compliance hearing, an evaluation, another treatment recommendation, and an extension or amendment of probation. In other words, the judge is no longer looking at this as one isolated failure in 2024. This is the state's strongest argument. The court has already tried multiple avenues to get Johnson into compliance. The question becomes whether another opportunity would realistically change the outcome. But then the defense fires back with an important mitigating fact. Johnson has never been arrested before this case. That matters because sentencing is not conducted in a vacuum. The judge has to consider the individual before the court, not simply compare her to someone else. So now we have two competing narratives, repeated opportunities versus a limited criminal history. Which one should carry more weight?
I wasn't paid for it. I actually finished, but I was let go a week early for my needs, like it was medical release. And I moved on to the sober living, and I didn't stay there. I got flagged for not coming in on time, and I just didn't stay. When they told me I had to wait 2 hours outside of for the sober living so I can come back in, I didn't stay. I just left. I didn't feel comfortable.
What do you mean you didn't feel comfortable?
I mean, just waiting there outside of the gate. That was one of the things that they do when you're late. When you
Those are called consequences, right?
Yes, ma'am.
Her family is here.
Mhm.
Here in the back. She has a place to go if the court can allow her back out again. And we have that set up.
Well, what I can tell you is I don't think a judgment satisfied is appropriate in this case. I don't think 2 years is appropriate in this case. You have done some things, but I'm not going to give you a judgment satisfied.
Okay.
All right. So, is there anything else? from either side?
191 days, Judge, would be fine.
Okay.
Yeah.
Yes, State?
Your Honor, Fisher was ordered to SATF on November 1st, 2021, but she failed to surrender at the Bexar County Jail for placement on December 9th, 2021. You allowed her to attend intensive outpatient treatment, but she failed to attend in August 2nd, 2022. There was a compliance hearing because of that, Your Honor. At the compliance hearing on October 25th, 2022, the defendant was ordered to complete a TAP evaluation, which recommended DDOP. But it did begin, that was in February 24, 2023, but was discharged 3 months later on May 23rd, 2023. Her probation has already been extended and amended for 6 months to include PDRF. Entered PDRF November 8, 2023, but was discharged March 4, 2024 with recommendation for safety. And here we are, Your Honor, after all this time, and you can't really help her with probation anymore. That's why State's making a recommendation that it is.
Judge, just a reminder, she has never been arrested before this case. This is the first one in. You gave her deferred. She did not do well, and we're not trying to hold her up as somebody who was perfect on her probation. But the amount of time that she's been in is certainly commensurate with what we've seen in this court on some other cases. And I don't think that it's inappropriate to consider something in that 180 to 190 day range, especially with no prior history.
Well, what I can tell everybody is I treat people as human beings, so everybody's case is different. What I may have given, person A, I don't give the person B because I'm treating people as individuals. All right, counsel, did you go over the trial court certification with her?
Let me have her sign it. All this means is that there's no plea bargain and you can appeal if you choose to.
Thank you.
No, you can say send we wanted you to go if you want.
All right, and
This is the moment where the uncertainty becomes very real. There is no sentencing agreement between the sides. The defense has asked the judge to consider roughly 180 to 190 days, particularly because Johnson has no prior criminal history and has already spent substantial time in custody. The state, meanwhile, has given the court a record of repeated interventions and treatment opportunities that did not produce sustained compliance. And the judge makes another important point. She does not sentence people by simply copying what happened in another case. She says she treats defendants as individuals. That means Johnson's sentence is supposed to be based on her record, her conduct, and her circumstances. There is also an important legal distinction here. Johnson was originally placed on deferred adjudication. The hearing is now about the court finding the alleged violation, adjudicating guilt, and imposing a sentence. Once the judge makes that decision, the consequences become much more serious than simply extending supervision again. And the judge's next words show that the court believes it has already tried to get Johnson's attention. The question now isn't whether the court gave her opportunities. The question is whether those opportunities were used.
in reviewing the file, I did see that in October, your conditions were altered and amended, and you were admonished not to miss any more appointments. And that was me trying to get your attention, and it did not work. Okay. So as previously stated, the court is finding violation of condition number 5 true. The court is going to grant the motion, find you guilty. The court is going to sentence you to 18 months in the state jail facility. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Yeah. Can you just make a copy of this? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And I will also request the therapeutic community. It doesn't increase the time that you're in custody, but they may be able to help you in regards to your rehabilitation. All right, good luck to you.
And there is the final ruling. The court found Carissa Johnson's violation of condition number 5 to be true, granted the state's motion, adjudicated her guilty, and sentenced her to 18 months in a state jail facility, with credit for time already served. That outcome is significant because the defense had asked the court to consider roughly 180 to 190 days, while the state presented a history of missed requirements, treatment problems, and previous attempts to bring Johnson into compliance. The judge ultimately chose a sentence longer than the defense requested, while also stopping short of the maximum 2-year state jail sentence described earlier in the hearing. The court also explained that Johnson has a limited right to appeal concerning the allegations in the motion, and because the resulting conviction is a felony, the judge advised her that she cannot possess or own weapons or ammunition. The judge additionally requested consideration for a therapeutic community program, emphasizing rehabilitation without increasing the custody term. So the big takeaway is accountability versus rehabilitation. Johnson's mental health struggles, treatment efforts, lack of prior arrest history, and time already served were presented as mitigating circumstances. But the court placed substantial weight on repeated opportunities to comply and the fact that prior warnings had not produced lasting compliance. Do you think 18 months was the right balance? Or should the court have accepted the defense request for credit around the 180 to 190 day range? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.